All right, guys. So welcome to this portion of our purchase and sale module. So I'm going to show you the real estate purchase contract that we use on all of our deals. This is a purchase contract that we kind of got from someone else a long time ago, and we just modified it to our liking, put a few things in there that we know we needed, had an attorney review it many times over the years, and this is what works for us. This is a 4-page contract, very simple, and something that you can use pretty much anywhere. Disclosure, we are not attorneys. We are not practicing law here. We're just giving you a contract that we use that you can use in your business. We advise that you have an attorney in your state look it over. Make sure that it abides by your state and your local laws. So when you use it, it works for what you need and keeps you out of trouble. All right. So full disclosure. All right. So let's get into the real estate purchase contract so you can understand how to better put your deals together and get them under contract. Because that's one of the biggest questions that we get is what kind of forms do you use and how do you use them? So here we go. All right, so the first part of the contract is pretty simple. This line right here is for the seller. So let's say you're purchasing this from John Doe. And you can also print these off and write it out. You don't have to type them in. Sometimes I like to type them in, or when I did acquisitions, I like to because it looked more professional. And then when I got to the property, I would just write in the dollar amount and any other information that I needed. So if we put in the buyer here, so professional home buyers, we are the buyer. And then the property address, we'll say 123 Main Street. This here is just some legal lingo. And we'll say Wichita, Kansas, 67214. Financing, so let's say we know they've already accepted $20,000 verbally, so I'm typing this up. If you're at the property with them, you want to write this amount in. You don't want to type it up before you go because that amount could change and they may tell you something that allows you to purchase the property cheaper, or you may have to pay more for it. Who knows? So if you're visiting the property, keep that blank. If you're in the office and you're negotiating with them at that point and you've agreed to it, you can type it in. If there's financing, I always strike this out in front of them because I don't do mine contingent upon financing. If you want to leave this contingency in there, this basically says if you don't get financing, you are able to back out of the contract. So if you're not confident on whether you can close or not and you need an out, I would leave this in for sure. Just make sure that you can prove that you applied for a loan application and you did try and get a loan on this property. Okay. Title evidence just says that you're going to get title evidence showing that the title is clear. And for those of you who don't know what title is, title basically is attached to the property that says whether there's any loans, liens, encumbrances, mechanics liens, taxes that the person owes, and many other things that can show that allows or doesn't allow someone to sell a property. So if you've got a tax lien or something like that, you're typically not able to sell a property if it's in your name. The great thing about what you guys are doing, if you put it in an LLC, or if I put in an LLC, I should say, and something happens with you personally, it doesn't affect what's in my LLC. Now, there's some ways that they could potentially get around it, but it's very costly for them to do that. But if your LLC and your personal name have something against it, it doesn't affect the other one. Okay, so if you want to go with, we use a company called Land Title for all of our closings. So this is who will do the title evidence and make sure that the lien, or excuse me, the title is clear and you can close on it. They are typically the ones that get the earnest money as well. So I typically do $100 earnest money. Some people teach not doing any. Some people teach to do $1. In my mind, if you go to court, you probably want at least $100 to be able to substantiate that you put a high enough earnest money down to make this a valid and legal and binding contract. They say you have to have valuable consideration when entering into a contract, and this is part of valuable consideration. And you can read that here in the lingo. And this says if you are back out for reasons in the contract, you get that money back. If you back out just because you feel like it, or it's not something that's in this contract, then they can keep that money as liquidated damages. Okay, so that shows it right there. I always put as of closing. So if you have a city or state that your taxes are in arrears and they haven't been paid for the previous year or the previous few months, then this shows that you will get credit for that, but then you'll have to pay it at the end of the year. So if you close in March, the seller may not have paid January, February, March. They will credit that to you so that you can pay it at the end of the year. Okay. Closing in possession, I always do 30 days out. So let's say 4, 15, 16. I'm just making that date up. So let's say that's 30 days out. That gives you plenty of time to close on the property. If you're wholesaling a property, of course, you want to do more time out, but typically 30 days is plenty enough for us to close. One of the benefits that we give our sellers sometimes is if we're really wanting this property and the seller is tough on their negotiations, we'll cross this out as well. So if you're at the property, you just exit out, you both initial it, and basically this just says that if you find termites on the property, they will treat for the termites, they will pay for it, and potentially any damages that you find. We probably 1 out of 10, we will ask for them to treat for termites because it needs it. So if they don't fuss about that, typically they don't, just leave it in there. And if you find termites, that's an extra $500 or $1,000 that it saves you from having to treat it. This varies from state to state, but this is negotiable. So this talks about title fees and closing fees. So if you want to market that you pay 100% of those, you can. For a property that's $20,000, which I know for some of you in your markets that's way low, but if even if it's $200,000, your closing fee, at least our closing fee, is going to be right around $250 for our side, and then between $100 and $500 for title insurance, depending on the price of the house. So you're looking at $350 potentially to $750 in closing costs that you're going to pay on your side, and then the buyer is going to pay the exact same thing on their side. So if you want to pay 100%, then you're going to need to change that and make sure you add that in as part of what you need to have on your deal analyzer when you go to sell. So again, 50% is typically what each pay, 50-50. If you want to pay 100%, you can as a benefit, or if you even want to negotiate them paying it. I don't necessarily recommend that because I think you're charging them a bunch of fees, and by that time they could say, well, I may as well go with a realtor because I didn't want to pay fees, right? So MLS deals, most likely it's going to be 50-50. So that's something, again, it's just completely negotiable. So like I said earlier, we usually cross out the financing part of it. We don't make our properties contingent on financing. If you want to do the same thing with an appraisal here, if you're not getting financing, or if you want to make it so that it's much more benefit to go with you over someone else, cross that out, no biggie. Here is the inspection clause. I always recommend keeping this one in unless you get a little more experienced and you just want to negotiate really tough and get your price and know that if you get your price that you can cross this out. But 9 times out of 10, we keep this in here. They don't even care. We get 10 business days to inspect. And if we find something within that 10 business days, we negotiate. If within 3 business days we can't come to a negotiation, we cancel the contract. It's null and void. We both walk away, and the buyer, which would be us at this point, would get our earnest money deposit back. So this gives you another opt-out in the contract. And many people put subject to final inspection in the last paragraph. I would recommend doing that if you're not real comfortable on whether you're going to go through with the property. If there could be some inspection issues, because that gives you an out from basically the end of the contract period. So 29th day of the 30th day, you say, I'm not good with the inspections anymore. I'm not good with the estimates I'm getting on the property. You can put in there in the last paragraph, subject to final inspection, subject to, pretty much subject to whatever, and make it so that if you're not happy at the end of the 30 days with what's going on, you can cancel the contract. I don't recommend doing that because you just want to cancel and you're just throwing offers out there and not intending to go through with them. That's just an out in case something happens. If you've got money that you're putting into it and something happens to your kids and you need that money, you're able to back out of it. If you think your budget's going to be 30 grand, you do your inspections, you're good with it, and all of a sudden you realize you're going to be 40 grand into it and the numbers just don't work, you've got an out. And remember, with this contract, you can negotiate with the seller afterwards. So let's say you do an inspection and you find $10,000 worth of repairs. Don't be afraid to go back and negotiate $10,000 worth of repairs to be taken off the price. If you find a septic tank or a plumbing issue and it's thousands of dollars, or even if it's $500 and it's not in your budget, don't be afraid to go back and negotiate. And the inspection period allows you to do that. Okay, so I just wanted to throw that in there. And here's a few more things legally that we put in our contracts. You get the buyer to sign, date, last 4 digits of their social, so you can match it up with title work. Same thing for yourself. If you're doing it in an LLC, then you don't need to put anything in here. You might put your tax ID number if you want to, but typically that's something a title company can look up. So pretty simple, straightforward contract. Just make sure you fill in all of the blanks. If for some reason there is, it needs to be crossed out, like financing, for instance, you can put NA if you're paying cash. And anything you can cross out in front of the buyer and say, or excuse me, in front of the seller and say, I'm a buyer that doesn't need financing, unlike, someone else who may buy your property. That's going to hold some weight because they're going to go, wow, if I go through another buyer, then they're going to need to get financing and it's not going to be as clean. So anytime you can cross out that or the appraisal part of it, and then maybe just put in, subject to final acceptance of the property in the last paragraph, I think that's totally fine. So again, I'm not practicing law here. I'm not, doing anything legal with you here. I'm giving you my contract that I use, showing you how I use it, and you can use it how you like, and it's up to your discrepancy. So take this, go put some deals together, and hopefully this will make you a lot of money. So we'll talk to you guys here all in the next video.